Any mention for unlisted matter? Any mention for unlisted matter? From supplementary list, item number 1.
Who's for the petitioner?
I am for the petitioner.
You're for the state?
State respondents, Your Lordship.
What is the stage of the proceedings?
It is in the evidence stage, Your Lordship.
Within the evidence stage?
10 witnesses have already been examined.
My Lord,
And this is pending before the Sessions Court at Shillong, Your Lordship.
they have made it the entire case into a suicide, my Lord. And my Lord, the petitioner here, she was the mother. And my Lord, she has expired.
Then?
That is...
And she was the only petitioner, Your Lordship.
She was the only petitioner here, my Lord, in this case.
Is there anyone willing to carry on the petition?
My Lord, I will inquire from...
Very well. The matter WPC number 169 of 2015 was disposed of by an order of March 22, 2016. Puts up. However, it has been brought to the notice of this court earlier this week. However, an order dated May 8, 2023 has been received by this court earlier this week, by which the Supreme Court has set aside the order of March 22, 2016 and has required this court, open court, to decide and dispose of the petition afresh in accordance with law and on its own merits, and taking into consideration the observations made by this court in the case of, within italics, Sushila Devi, then bracket supra, bracket close, comma, referred to here and above, and other relevant material on record, and may also consider whether the investigation is to be handed over to another agency or not. Dot, 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 close quote. Paragraph. It is submitted on behalf of the erstwhile petitioner, comma, the mother of a deceased police officer who suffered an unnatural death, comma, that the petitioner has died, full stop. Counsel will take instructions as to whether there is anyone interested in pursuing the petition, full stop. Paragraph. On behalf of the state, it is submitted that the criminal trial is proceeding in right earnest before the Sessions Judge Shillong,
Yes, Your Lordship.
and more than 10 witnesses
Yes.
have been examined. Full stop. The matter will appear a fortnight hence, and even if none is interested in pursuing the petition, comma, in view of the circumstances in which the petition was filed, comma, the court may look into the papers and make appropriate orders in accordance with law on its own motion. We want to see the charge sheet. We want to see the evidence that has happened so far. We will look into it, and we will possibly require a further investigation to be conducted, probably by a special investigation team, which we will handpick, or we may hand it over to the Central Bureau of Investigation.
From the main list, item number 1.
This is the matter which was remanded back from the Honorable Supreme Court. This is the matter which was remanded back from the Honorable Supreme Court regarding the CPF fund for the teachers of the aided colleges, my lord.
Yes.
On the last occasion, my lord, the government was required to put up a scheme, and we were supposed to respond to that scheme, giving our inputs.
Yes.
My lord, there were some discussions, I am told, with the government and the MCTA members. My lord, yet we had to receive.
We have formulated we have issued notification in terms of the act, my lord. It was issued 2 days back only, and
The state says that a notification, give us the copy, please. That a notification has been published
Yes. Something has come up.
on May 29, 2023. Notification has been issued on May 29, 2023 by the Education Department in supersession of a previous notification of April 13, 2018, full stop. Paragraph. Such notification provides that all employees of the deficit colleges should be included in the new pension scheme by converting the contributory provident fund contribution with effect from April 1, 2010. Accordingly, the employers are required to provide NPS facilities to the employees, failing which the employers would be held responsible. Full stop. Paragraph. Since a copy of such notification has been made over to advocate for the petitioner in court today, let the matter appear a fortnight hence.
One more notification is, my lord. Second notification is also there.
Let me just point out that the first notification is for persons who have joined after 1/4/2010, and the next notification is for persons who have joined before 2010. That CPF account was in issue before this honorable court. The second notification is more important, my lord.
Very well. Then after talk about the notification, a second, more important notification has been issued also on May 29, 2023, pertaining to non-government school and college employees appointed on sanction posts who joined regular service prior to April 1, 2010. The writ petitioner says that the second notification covers the area of dispute involved in these proceedings. Full stop. Paragraph. Since copies of such notifications have been made over to advocate for the petitioning association in court today, let the matter appear a fortnight hence for the association to respond thereto. Full stop. In the meantime, if the association has any suggestions, the same may be directly communicated to the state, to the secretary, to the education department, without waiting for the adjourned date. Not without waiting, prior to the adjourned date.
My lord, in this case, I am representing the college authorities. Copy of the notification may be given
Very
and
well, the college authorities, what respondents are you, madam?
number 4 and 5.
The respondent numbers 4 and 5, the college authorities,
Yes.
are represented. Full stop. Copies of the notifications should be handed over to all respondents seeking it in course of the day.
Obliged, my lord.
Seeking them.
Item number 2.
Here there are three analogous appeals.
Two, my lord.
Two.
Two, my lord. 4 and 5, my lord. My lord, the case in the gist here is that an FIR was filed by the complainant stating that his son is missing. His son is missing, my lord. Missing complaint was filed. And thereafter, my lord, an FIR was filed and investigation was done, my lord. Both the appellants were arrested and the body of the victim was found in a jungle in Garo Hills, in Amzonga jungle in Gwalpara district of Assam, my lord. The victim and the complainant are from Ribhoy district, Pilankata, my lord. It comes under Pilankata outpost, my lord. My lord, my case is that there were 9 accused in the case. The charge sheet says there are 9 accused in the case. Only 3 were arrested, my lord.
Only 3 were?
Arrested, my lord. 3 were arrested. Now, one absconded before the trial could begin, my lord. So, both the present appellant faced the trial, my lord. And both were convicted, my lord. Now, my ground for appeal is that, my lord, there were serious contradictions in the evidence, my lord, and in the investigation. And the first ground I am taking is that the prime witness in the case was never examined. She was the sister of the victim, my lord. She was 11 years of age, my lord. And she was the one who apparently saw that the victim left with the appellant.
Victim left
with the appellant, my lord. My lord, appellant came to her house and asked the sister of the victim to call her brother. She went inside, called the brother, and she was the one who last saw him going with the appellant. And
how old was the brother, the victim?
Victim 16 years.
16?
16, man. 16. Thereafter, my lord, the informant says that one of the cousin brother of the appellant informed him that he saw the victim going with the appellant. Now, the brother who had told the informant that I saw your son going with the appellant, he mentions a small boy. In evidence, he says, I saw a small boy going with the appellant. Now, the small boy is nowhere connected to 16-year-old boy, the victim, my lord. Thereafter, my lord, there are allegations that...
How do you know? How do you arrive at that conclusion, small boy?
He says small boy.
So why do you think small boy is this small boy?
No, my lord, small
boy could be not full-grown boy.
My lord,
that's
not
full-grown
boy.
At 16, you are not full-grown.
My lord.
You have chance to grow even at 18, 19.
My lord.
So therefore, small over there, unless he showed small boy like this.
Admitted, my lord. You know, but the small boy will for a 7.
The real clue is when Amitabh Bachchan brings the second hand in describing the
my lord, but
so
here,
without the second hand, first hand does not mean anything.
My lord, but what I am trying to put across, my lord, is a small boy in this context will be for a 70-year-old man. If a 70-year-old man says that small boy, he may be of 16 years, he may be of 20 years old, but he himself is about 25 years of age, my lord. So when he says I saw a small boy, it cannot be 16-year-old boy, my lord. My lord, thereafter,
in fact,
my lord,
you'd be surprised. 25-year-olds are more conscious of how big they are than 16-year-olds, than 70-year-olds, 16-year-olds.
My lord, but there are other
when you're 1 class or 2 classes junior or senior,
my lord,
at that level, that's a big difference.
My lord.
But later in life, it's not a difference at all. So, when a 25-year-old says small boy, anyway, it doesn't mean anything.
So, thereafter, my lord, then again there are contradictions. The police examined the most important thing, my lord. The present appellant was arrested and he made up a story. This is what
present appellant
was arrested, my lord. Arrested after 5 days of missing of the victim, my lord. He was arrested. Apparently, he made up a story that I was also kidnapped along with the victim, and I managed to escape from there. And he was arrested by he presented himself before a line hotel in Dudhnoi district, my lord. And those people took him to police station, and then he was in turn brought before the present IO, my lord. Now, at that point of time, my lord, the investigating officer did not deem it proper to see the call detail location, my lord. The location of the mobile phone of the appellant, my lord. that whether he was present there at that point of time, though the mobile was seized, my lord, of the appellant. But call location details were never brought before the trial court, my lord. So whether he was present there at that point of time could have been managed, my lord.
Present where?
Present, the allegation was that the appellant took the victim and handed over to these dreaded criminals, my lord, and Mzonga jungle. And he was also there for 4-5 days, my lord.
How was the body discovered?
Discovered, again there is a contradiction, because the father says, who lodged the complaint that I was led by the second appellant. We were led by the second appellant. But police says that we were led by the first appellant. And again, my lord, the body
Is it the evidence that both the appellants accompanied?
No, accompanied, there's a disclosure saying that accompanied.
Did both the appellants accompany when the body was discovered?
Silent. It is silent. It is silent. They are saying the accused led us. The accused led us.
The
now,
accused
investigating
would be
both, my lord. But again,
there's a section 34 also.
Section 34 also, my lord. But investigating officer says that the present appellant led me.
All right.
But father says that the second appellant led us there. Now the body was highly decomposed, my lord. Now it was only identified by the clothes which the last victim was wearing, my lord, and nothing. No DNA was done. No call record details were brought, my lord. At the same time, my lord, there are serious discrepancies when the absconding accused said that I heard a gunshot and he was killed with a gun by a bullet wound.
Absconding accused?
The third accused who was arrested, my lord.
Yes.
He gave a statement, and even the investigating officer says so, that the statements are there that he was killed by a bullet injury, the victim. But postmortem report says something else, my lord. So this is another contradiction.
That the third, the absconding witness who has not been subjected to cross-examination,
the IO also says that, my lord.
His statement without subjecting him to cross-examination has no relevance at all.
No, agreed, my lord.
It's a 161 statement, it has no effect.
No, 161 was also recorded. He absconded before that, my lord.
Then how was the statement?
No, they are saying after arrested when he was interrogated.
So this is a hearsay evidence of
hearsay.
The investigating officer as to what one of the accused upon being arrested said.
And the appellant
utterly
my lord, the appellant also says that I heard a gun wound, a gunshot. The appellant. Appellant also says,
I heard a gunshot.
I heard a gunshot and he was killed. And a third, the one was not arrested.
The appellant says he heard a gunshot.
Yes, my lord.
Then the appellant's presence at the place of occurrence is confirmed. Your submission nails him straight.
Oh, no, I'm corrected, my lord. The investigating officer says so. The investigating officer says so, my lord. I stand corrected, my lord. The charge sheet speech, I may be allowed to read the charge sheet because there are serious contradictions in the charge sheet, my lord.
Contradictions won't do. Your admission is good enough.
No, this is not an admission, my lord. I stand corrected, but it is the investigating officer who says so. Now, my lord, when admittedly, even if we admit, my lord, that I led them there, my lord, the police did not.
What does the postmortem report show? How was he killed?
He was killed. He was beheaded, my lord. Incised wound.
And there was no gunshot injury, which was.
No, my lord, no. And no murder weapon was neither recovered. Nothing was recovered. And the investigating officer did not deem it proper to take a magistrate because there was a disclosure, my lord, to recover the body. No independent witnesses there except the headman's, my lord. My lord, he did not take a professional photographer also to take. He's saying, it is on record. He's saying that it was dark and I took some pictures from my mobile phone. That's it, my lord. My lord, then there are serious contradictions. Even the judgment says that he was killed by a bullet injury. The trial court's judgment speaks that the victim died of a bullet injury, my lord. But postmortem report clearly differs from that. There are serious contradictions in the evidences as well, my lord. The entire case, what I'm submitting humbly is that the entire case is based on circumstantial evidence, my lord, and the last scene theory. Now, last scene theory is neither the last scene theory is corroborated nor the circumstantial chain of evidence is complete, my lord.
It's good enough.
No, my lord,
good enough by virtue of section 27 of the Evidence Act. It's good enough that the two of you have led them to the body. After that, nothing else is necessary. X may have murdered, but that shows and you are a co-accused with section 34. So whatever X does, all of you are equally guilty.
My lord,
You know, one may pull the trigger or one may behead, but when several people do it together with a common motive, then the offence is attributable to each one of those persons.
my lord, here the appellant, there is nothing to show that I killed him, my lord. There is nothing to show that I killed him.
Ayo says that you took him. Father says the second appellant took him.
Yes, my lord. Took him.
So the two of you took them along.
My lord, the second appellant's case, with all due respect, is little different, my lord. My lord,
Again with 34.
Again, no, my lord, he was forced at gunpoint to cook for them.
He was?
He was forced at gunpoint, my lord, that you cook food for us.
That's his statement.
That is his statement, my lord.
How does he prove that?
My lord, there's nothing to prove because
Then
the
that's his statement that he was
even the
at that
investigating
point.
officer also says so, my lord.
Investigating officer has no right to say anything on these
My lord,
matters.
the entire case was based.
It's an unsubstantiated statement by an accused that he was forced. Now, if I am forced at gunpoint to pull the trigger on somebody else, I have to prove.
My lord, but the investigating officer, when he files a charge sheet, his charge sheet ought to be based on some kind of evidence, my lord. There is a contradiction in the charge sheet itself, my lord. He is contradicting at one place and he is not contradicting at the second place, my lord. My lord, if I may allow to read that part, my lord.
We'll read everything, but before that, the basic edifice of your case is.
My lord, last scene theory is not substantial.
Forget last scene. The two of you took them. There was a section 34. You have not called any witness. You have not called any witness.
No, my lord.
You know, when you have to be rational and reasonable. No criminal invites an IPL crowd to evidence the commission of an offence.
My lord.
Every criminal and his brother would try to go away from a place where there would be many eyes, as in a jungle. Now we have to then use our rational sense to understand what we can discover in such circumstances. And when otherwise everyone will go to a quiet place, commit a murder, and then come back and there's no witnesses and go scot-free.
My lord, but I have not been indicated anywhere. Indicated in the sense, my lord, when my presence was first discovered when I was arrested there, no call detailed location was found that whether I was actually present there or not. Nothing.
In your 313, was it put to you that you took the police to the place of occurrence? And what is your response?
It is at the supplementary paper book, my lord.
Yes.
Page 1, my lord. Yes, my lord. He merely denied it, my lord, at question number 6.
And what did he say? What is his answer?
It is not a fact, my lord.
Very well. What is his answer to question number 1?
It transpires. I do not know who is the informant in the
What is his answer to question number 7?
Number 7, I do not know, my lord.
So the trend is the same.
Trend is same, my lord.
The trend is the same. Did he make any positive statement in his 313?
No, my lord. Now, question number 30, my lord, which was put before the court. The question was, it transpires from the evidence of PW 11, the investigating officer of the case, my lord, that you leading, he along with forces went to Borjar Garopara village, and while walking towards the village, you identified co-accused Akwit Armara, who was also a part of the miscreant, and accordingly co-accused was detained and interrogated. And co-accused Akwit Armara reveals he resides Borjar and he used to cook food for you all and he dropped food to reserve forest where you and co-accused were stationed. What do you have to say? It is not a fact. He has denied it. Now, question number 32, my lord. He says it transpires from the evidence of PW 11 that on leading by you and co-accused Acquit or Marak, a search was conducted to recover or trace out the victim, so and so, but could not found. What do you have to say?
Very well.
So,
Yes, proceed in your own way.
with the FIR, my lord?
Yes, whatever you want to.
My lord, the typed copy of FIR is at page 2, my lord, of the paper book.
How long will you take?
I have made a gist, my lord, on bullet points. I will point out
No,
something. Half an hour.
Do it properly. Don't.
Half an hour, my lord.
That's good.
My lord, the FIR says with reference to the, at page 2, my lord.
Page 2.
Page 2, my lord, of the paper book. With reference to the subject cited above, I would like to file an FIR on this date, the 23rd October 2015, that on 21st October at about 10 a.m., my son went out from home along with the first appellant, my lord. He names him.
What is the date of the FIR?
Date of the FIR is 23rd, my lord. 23/10/2015.
Yes.
He files a missing report of his Pilankata police outpost under Khanapada police station, my lord, in Ribhoy district. My lord, here he names the appellant.
Oh, there is a ransom call also.
Yes, my lord. A demand of 10 lakh rupees was made to them. My lord, may kindly come to page 21, my lord.
Yes.
This is the brief story of the case in the charge sheet, my lord. May I read it, my lord? The prosecution story of the case is that on 23/10/2015 at about 5 p.m.
Just. Yes.
The prosecution story of the case is that on 23/10/2015 at about 5 p.m. one Shri Rahim D. Sangma, son of so and so, appeared at the OP and submitted a written FIR to the effect that on 21/10/2015 at about 10 a.m. his son, so and so, 16 years, went out from home along with the appellant, Sri Ajay Sangma of Chibra village, PS Khanapada, PO Pilankata, and had not returned since then. However, on 22/10/2015 at about 11 a.m. he received a call on his mobile number so and so from unknown mobile number so and so, and demanding a ransom. Demanding the sum of rupees 10 lakh as ransom for the release of his son, and the person were communicating in Garo and Assamese languages and also warned not to approach the police for help. The case was started and I, SIK Thapa, took up the investigation of the case. During the course of investigation, visited the PO is that so and so, Meghalaya, which is approximately 3 kilometers so and so from the OP, held confidential inquiry and learned that on 21/10/2015 at about 10 a.m. Master Prem D. Sangma, 16 years, son of so and so, Meghalaya, was at home. Meanwhile, Sri Ajay Sangma of Chibra village of so and so was standing outside the house of the victim of Master Prem D. Sangma and asked his sister, Miss so and so, 11 years, to call his brother outside as he wanted to talk to him, who was at time was inside the house. Accordingly, she went and called him, and her mother, Srimati Dorchon D. Sangma, out of curiosity, went at him and saw Ajay and Sangma were standing near the gate. Now, my lord, if I may point out, Dorchon D. Sangma is the mother of the victim, my lord, and she is PW2, and she has not stated that I came out and saw the accused. She has not stated that in a deposition, my lord. Then Master Prem D. Sangma went and met him Ajay Sangma. For a while they had a conversation and left, and was seen both of them were travelling in a commercial vehicle taxi, white magic van number not known, proceeding towards Basishta Charayali, Guwahati, Assam, and since then he, as well as Ajay Sangma, has not returned back. On further inquiry, it appears that the victim was kidnapped for ransom by applying inducement by deceitful means by Shri Ajay Sangma and other unknown person. A secret inquiry was held. However, nobody could provide the information of the victim as well as the Ajay Sangma apparently kidnapper. Now, my lord, it is to be noted that the victim father, Shri Rahim D. Sangma, had already received a call on his mobile number so-and-so from unknown mobile number and demanding a sum of 10 lakh rupees as a ransom for the release of his son on 22/10/2015 at 11 am, and source has been engaged. Accordingly, call detail record, customer application form of the unknown mobile number obtained from the service provider for the interest of the case. On analysis, conversation has started from date 22/10/2015 at 11:10:03 am up to the date 27/10/2015 with the complainant mobile number so-and-so. Also received the customer application form from the mobile number which was in the name of Shri Payal Mahato of Dimapur, Nagaland. It is Airtel prepaid SIM card. In order to verify the same, WT message has been flashed to OC Dipu Par, Dimapur, Nagaland, but no reply. It appears that the said SIM card which has been used by the kidnapper is black SIM card which have the identity of the other people. Therefore, it is difficult to trace out. Examine number of witnesses and engage source. During the further course of investigation, accused Ajay and Sangma was arrested and taken into police custody. He was thoroughly interrogated. While in custody, he told that he and victim Prem D. Sangma had been kidnapped by some unknown persons from Basishta Mandir, and he was shot twice by the unknown person in where he pretended to be dead. He also showed his woolen jacket to prove he was shot, and it has got torn or cut on the right side of the jacket. Accordingly, in order to verify his statement, the woolen jacket was sent to Forensic Science Laboratory in order to determine whether the torn or cut was actually caused by the gunshot. However, on receipt of the Forensic Science Laboratory report, Shri so-and-so, Physical Division so-and-so, opined that gunpowder residue could not be detected, which means it had no gunshot. On further interrogation, he revealed he made up his own story in order to avoid any suspicion detection from the police against him. He was seen going out together with Prem D. Sangma on 21/10/2015 by witnesses Dorchon D. Sangma and Dear Sangma. Now, Dorchon D. Sangma is the mother, my lord, and Dear Sangma is the cousin brother of the appellant, my lord. Now, there is I will take your lordship to the evidence, my lord. They have contradicted, my lord. He also revealed that the whole plan was construed by the person with Anthony G. Momin for kidnapping the victim Prem D. Sangma and was offered an amount of 10,000. Efforts were made to arrest the Anthony G. Sangma but in vain. Momin. The accused Ajay and Sangma expressed his willingness to lead the police party to arrest the other accused on his leading during his period in police custody. One of the accused, second appellant, my lord, Akwit R. Marak, was arrested from the village Borjhar, Garopada, PS Dudnoy, district Golpada, Assam. He was also arrested and taken into police custody. During their period in police custody, they were interrogated thoroughly. During the course of investigation, both of their statements contradicts with each other and pressure was given to them to tell the truth. And finally, they revealed that the victim, Prem D. Sangma, is killed and was thrown at the reserve forest. However, they denied in telling the truth who killed victim Prem D. Sangma, but they expressed their willingness to lead the police party to recover the dead body of Prem D. Sangma.
However, they denied in telling the truth who killed, but they expressed their willingness to lead. So both of them.
Both of them.
On their leading.
On their leading.
So not on Ajay.
Not
on their leading.
Yes, my lord. But the complainants.
That's a different thing. That's a different thing.
Different, my lord. But charge sheet says so.
What you said in the police, that is incorrect.
Incorrect.
It's both.
Both. It's both.
That's the end of your case. In the presence of independent witnesses, so and so, so and so, so and so, The dead body was recovered from the reserve forest in a highly decomposed state. Held inquest, could not find, dead body was brought. Although did shock of hemorrhage caused due to incised wound on neck by sharp object. 3 and 2.
Was added, my lord.
On received source information that one of the co-accused, Sensan
Yes, ma'am.
Sangma,
Yes, my lord.
was arrested and is in judicial custody. Now that person is now absconding.
Absconding, my lord.
The essence in the production warrant and interrogate thoroughly where he recorded statement voluntarily confessed his guilt that he was also involved with the police power to arrest the other co-accused. However, he denies involvement killing the victim. On his deeding during his police custody, raid was conducted, house of Tonoboro,
The
Tom
other,
Daimari, Grething Marak, Anthony Momin,
my lord.
what is Bain?
Gautam Basumatari, my lord.
Yes, that's the same.
Same. Greeting Marak, thereafter, my lord, Anthony G. Momin, but in vain.
Held inquiry openly and secretly.
But nobody could provide the information
Made
of their whereabouts.
Altogether, Johnson statement are accused that 9 people were involved, of which only 3 are arrested, 6 are at large. If they are arrested, they are available accused. So, is there any justification for a split trial?
The reason, my lord, there is evidence which shows that the second appellant, my lord, he was merely cooking, my lord, and there are statements, my lord, which says that he was forced to cook. There was a threat, my lord, to him. Now, my lord,
Sorry, what is your name, sir?
M. Sharma, my lord. M. Sharma, my lord.
Mr. Sharma, let us say 4 of us plan to commit this murder. And we say that we'll go to the middle of a jungle and commit the murder. I am given the responsibility of showing the way by using a searchlight. Another is given the job of preparing snacks because we'll have to eat inside the jungle. A third is given the job of actually killing. And the fourth is given the job of getting rid of the body. Can you attribute individual acts to individual persons when there's a commonality in motive and that commonality is there included in 34? Whatever I do gets attributed to him, whatever he does gets attributed to me. Some persons acting in concert made out a conspiracy to commit this thing. The individual roles that they play over there is utterly irrelevant. It is evident from this, including the fact that ransom call is proved, that it was a concerted effort.
No, but the caller was never traced, my lord.
Maybe.
Caller was
but
never
the call
traced.
is proved.
The call is proved, but somebody had made a call, my lord. That
Call
was
is
never
proved.
Call is proved, my lord.
Now, to what extent do you want us to become idiots
No.
when it comes to criminal trials?
No, my lord.
We will shut our eyes, we will let our senses go to sleep,
No,
we will
not
not
at all.
hear anything,
With all
we
due
will be like
respect,
the
no,
3
my lord.
monkeys.
No, not at all, my lord. With all due respect, no, my lord. But there are the evidence, my lord, the depositions. My lord, this sister was never examined. Actually, he went with them or not.
What was the need? The 2 of you led to the place of occurrence from where the body was recovered
My lord,
in the presence of so many witnesses. What else is necessary?
My lord, then there is a judgment from Apex Court, my lord, which says that no DNA was done. Now the body was decomposed, my lord.
When people go to Delhi, they suddenly realize DNA. They don't realize what the actual nitty-gritties are. How much money is allotted to a police station to conduct those things?
My lord, then another thing, my lord. My lord,
What was the DNA necessary over here? He was identified on the basis of his clothes.
Clothes, my lord, and the body was highly decomposed, my lord.
May have been decomposed. You took him there. Where is the doubt over here?
My lord,
You took the party over there.
yeah, but that disclosure statement was never recorded, my lord. My lord, if he admit that the
The disclosure
appellant-
statement is irrelevant. Because all that is required to be seen is as a result of your conduct or act.
my lord,
If anything incriminating is found against you, that statement is irrelevant, is inadmissible. It's the consequence of the statement which is important. The consequence of the statement is the murder weapon was found or the dead body was found. It's only the consequence which you can be looked into. Look at section 27.
27, my lord, there's a disclosure, my lord. But what I am saying with all due some respect, my lord, the IO did not record the disclosure. It was stated before.
All right, it was an oral statement.
Oral statement, my lord.
Oral statement. The fact of the pudding is in the eating. Ultimately, the two of you led them to the decomposed body.
No, not at the exact location, my lord. They had to search for it.
Oh, naturally.
They had
if
to
it's
search
in
for
a
it.
jungle, you have to search.
So they were not let pinpointly that this is the body. Here we had
That
killed
is
him or
not the
anything.
requirement in law also.
No, it is not, my lord. It is not.
They
my
were
lord.
not.
But at the
They were
same,
not searching. They were not searching in Kaziranga.
No,
Nor in Jaldapada.
no, my lord. My lord. But at the same time, my lord, the first time his call detail locations were not found there, my lord. The police is silent on that. My lord, what I am trying to attribute is that, my lord, the circumstantial evidence is not complete, my lord, because there are discrepancies, my lord.
Circumstantial evidence is when there is nothing else. Over here, there is direct evidence when you lead them to the body.
Body, but
That's
30
direct evidence.
direct, my lord.
Circumstantial is not necessary.
No, my lord.
When you lead them to the body, then it becomes incumbent on you to demonstrate how did you know that the body was there. It can be the two of us go playing football and we find there's a body, we run away because we are scared. Later we are arrested and then we take them to the body and then we say, look, what we did was we came to play football, but we found the body, we were scared, we ran away. Then there is a question of finding out how did the body come over there.
My lord, but the police is silent. Who killed the victim? 302, my lord. Who killed the victim?
It's obvious. If I lead the investigating agency to the dead body without any explanation as to how I discovered the dead body, nothing else requires to be proved. Last scene, first scene, circumstantial law, everything goes. This is direct evidence. Nothing can be more direct than this. And this is not in a city. This is not in a ditch by a road. This is inside a jungle.
It's a jungle, my lord.
And naturally, you wouldn't know the whereabouts inside the jungle. So you give the general location. After that, there's a search which has to be made. That itself is good enough. The only thing that you can do is you can throw the law at us saying that no, in such a situation it will not do. For us, section 27, you are leading them and this statement is, it's over. Nothing else is necessary. Plus, the general circumstances are corroborated, that a boy went missing, that a ransom call was received. These are all corroborated. We don't carry out investigation like they do in the United States or elsewhere. We don't have either an educated police force, nor do we have the funds dedicated for that purpose. That's why a whole lot of, particularly the rich criminals who can afford good lawyers, get away because they can pinpoint all. But that does not mean that because of that we will not convict at all. Yes, you're right. DNA should have been obtained. How he came to that place should have been obtained.
My entire case rests on that, my lord.
It's just that, just shut your eyes and think. Two persons, as part of a conspiracy under 34, common intention, lead a police party accompanied by others to a location in a jungle.
My lord.
That by itself is... Consider it, we are not finishing it off today. Don't want to send two together. I've never been a criminal lawyer myself. Don't want to send two together on the same day. But just consider this. And then throw the law at us.
My lord.
Your best. That, and we will confine ourselves only to this. The rest we'll forget about. We'll confine ourselves only to this. So you have better ground to attack. That only this in law is not enough.
My lord.
We won't go to brother, sister, this, that, anywhere else. Only that the two of you led them to a remote jungle and generally indicated the area where they had to search and dig out the body.
My lord.
You can come tomorrow if you want.
My lord, it may come up.
Very well. The matter is heard to some extent and adjourned for a week.
My lord, for a week.
Middle of next week?
Middle of next week. My lord, if I may be permitted, my lord, I'm going for leave, my lord, from 5th.
When will you be back?
After 15th, my lord. 17th I will be, 17th.
And we adjourn for a fortnight. That the matter, 17th is what day of the week?
Wednesday, 17th will be, well, Saturday is Saturday.
Saturday.
Saturday. Let the matter appear on the Monday,
My lord.
which is 19th.
19th. Deeply appreciated.
Item number 6.
Same is connected? No.
No.
Oh.
4 and 5 are connected, my lord.